Good afternoon, everybody. I'm Melissa Steinman. I'm a partner at Venable LLP, and thank you for joining us for Social Media Promotions 101. Let's get right to it. Everybody loves a good sweepstakes, and let's talk about the laws that underpin that. Here's the information about CLE credits. A code will be distributed through the Q&A chat at the end of the program for the important stuff, and then a CLE submission form will be sent to participants next week via email. So, in terms of what we're going to talk about today, we'll talk a little bit about what's new this year, but mostly we're going to talk about the basics here. What's the legal framework? Almost just as important, what are the platform rules? A little bit about endorsements and testimonials, the FTC's guide, which they announced yesterday. They'll be updating and are seeking comments on. The rules for sweepstakes and contests directed towards children. The privacy rules as they pertain to sweepstakes. A little bit about can spam. Charitable promotions. What's the international framework and how does it vary from U.S. rules, and then some practice tips. So let's get started. There's a lot to cover in the hour or so we have here. So what's new this year? Sweepstakes have been around forever, but there's a little bit of the more things change, the more they stay the same. We've seen a case out of the FTC. The FTC is constantly monitoring sweepstakes. They tend to look primarily at the sort of most fraudulent cases, but this year they went after a company called NextGen Inc., probably their biggest case. There was very substantial money involved. Working with the Missouri Attorney General, they settled with NextGen and some related defendants, which had sent mailers informing consumers that they had won, but would first need to pay a fee to collect the prize. Other mailers had been disguised as newsletter subscriptions or games of skill that involved a fee and ultimately an unsolvable puzzle. So this is a not unusual tactic, the sort of you've already won, you need to pay something, but the money involved is sort of breathtaking. $21 million in cash plus personal property and liquidation of the companies with a suspended judgment of $114.7 million. The settlement also required that the companies be wound down and liquidated and banned the defendants from prize promotion unless the consumers sign up in person. So that's pretty severe. The FTC publishes reports and sort of consistently lists sweepstakes at the top of their consumer fraud list. So they are always keeping an eye on these things, and as you can see, the Missouri Attorney General was involved. They're also looking out for problem sweepstakes. We'll talk a little bit about some of the Attorney General's settlements that we've seen over the years in the course of this presentation. Another case from this year was Indiana versus Hopkins and Raines, where the Indiana Attorney General sued a marketer that ran ads on behalf of car dealerships and sent mailers to consumers saying, you've won a prize based on a specific combination of winning numbers and symbols, where everybody had actually received the same combination. And the prizes that they actually got were much smaller. So the prize notice said that people had won cars or flat-screen televisions, but the actual prizes they got were things like small gift cards or lottery tickets or MP3 players. And, of course, again, a payment was involved. So they had to pay, say, $20 in taxes for the smartwatch. Also here, it wasn't really a sweepstakes. So the representation was, you won this, but, in fact, it was really more of what we would say was a free gift because there wasn't any chance involved. So the settlement there made it clear that if chance isn't a factor, you shouldn't be calling it a sweepstakes. So two settlements making it very clear that the regulators are keeping track of fraudulent sweepstakes, sweepstakes that aren't really sweepstakes at all, sweepstakes that require payment in order to redeem prizes. So that's sort of, there's hidden consideration in there, which is an issue that sometimes comes up with clients that I'll be counseling where, you have to pay some amount of money in order to redeem the prize. Is that consideration? Obviously, this settlement with Hopkins and Raines involved more than just the issue of sort of I have to pay to redeem. It wasn't a sweepstakes at all, but that issue of having to pay something in order to redeem your prize can come up in, say, travel sweepstakes where you're not paying for all of the travel prize. You're just paying for, say, the hotel and some other feature, but not the plane ticket. So a consideration to think about. We're not just seeing litigation. We didn't just see litigation this year. In May of 2019, Google got in trouble with a sweepstakes it promoted for its Google Assistant, a refer a friend sweepstakes that it offered for some of its users through its email. A consumer group called Mouseprint notified them that the sweepstakes that it offered unlawfully required purchase. Essentially, they had offered get a Google Home Mini 2-pack and enter to win a free speaker. So the offer required purchase. It said, buy this, and you'll be entered to win a free speaker. So there was a purchase required. The other thing you could do was refer a friend. If you referred a friend and they bought a speaker, you could also win or be entered to win. After consumer complaints through this group, Mouseprint, Google amended the sweepstakes in order to include a free alternative method of entry and provided notice of the change through another email. So that's, sometimes you end up in this problem where you get substantial pushback through consumer groups or your consumers, and you're left with this issue of, do we change this? We've got a sweepstakes up and running, but it's never a good idea to change a sweepstakes. And so, what do? Regardless of whether it's not generally a good idea to change a sweepstakes to open it up to lots of extra people due to fairness concerns. You may get complaints from your initial applicants or your initial entrants, rather. It certainly is going to be a good idea if you have a problem with potential illegality to make sure that that promotion is legal. So let's take it back to first principles and talk about how do we review a prize promotion. There are lots of laws, federal, state, and the like, but the first thing you want to do when you review a prize promotion is to make sure that it's not an illegal lottery, which is gambling and thus a criminal offense. So a lottery has 3 elements. Those 3 elements are first, there's a prize, typically pretty easy to determine. The second one is that there's chance. You're picking your winners through a drawing is typically where you see that chance element. It could also be that it's the 100th person to walk in the door, or the 100th person, we're talking about social media, the 100th person to like your post, or to sign up, or to comment on something like that. And then typically the most difficult issue is there consideration? Are participants required to submit consideration in order to enter? Consideration is typically, and in most states, can only be monetary, so something like a payment or a purchase, like the Google speakers we saw in the case we just talked about. But in a not insubstantial group, a number of states, consideration can also be non-monetary. So as we learned in law school, for those of us who went to law school, even a peppercorn may suffice. There are states who use the contract definition of non-monetary consideration. It can be an economic benefit to the sponsor, or some commitment of time or effort, or the like, when we're talking about the entrant. Things that we see being determined under sort of the case law or attorney general opinions in the states that say non-monetary consideration, things like a requirement, in a couple of states, a requirement that you go to the store. A couple of more states, it has to be something more than that, but a requirement that you go to the store several times, or that you undertake multiple activities, that you go to the dealership for a car dealership and you take a ride, that you take a survey. Generally, a few questions is okay. That takes just, a minute, but taking a lengthy survey, probably consideration. Submitting just your email so you can hear if you won, okay. Submitting substantial amounts of personal information in this, era where we're so protective of personal information, potentially problematic. So this is the type of analysis that you need to make. Now, if you decide that there is consideration, it's important. It is a situation where something like a free alternative method of entry, that 3x5 card that we're also used to seeing in sweepstakes, an email, something like that, often may solve that consideration problem with two caveats. The free alternative method of entry has to be given what we call equal dignity to the consideration method of entry. So it has to be, you have to have an equal opportunity to win. So in the same prize pool, you have to be allowed the same number of times to enter. You can't let the person who purchases get an unlimited number of opportunities to enter and then only say you can enter once for free. You have to have unlimited times to enter for free. Sometimes you put a cap on both, and it may be necessary, in fact, on some of the social media platforms that don't allow unlimited entries, unlimited tweets, say, or the like. But it's that idea of equal, whether it's free or purchase or the like. Also, you have to disclose clearly and conspicuously for the free alternative method of entry. There's that instinct to bury it when it comes to the free method of entry that you really cannot succumb to. That is an area that's been the subject of enforcement, particularly with the New York Attorney General. We'll talk about those cases a little bit and what some of the details in a little while, but it's something to keep in mind. One note that if one of these elements is missing, obviously you're working to eliminate the consideration in a lot of situations, but there are other types of promotions where an element is missing. If you don't have, say, chance, and everybody gets the prize, it may be a free gift promotion. Different rules apply there. There are disclosures you want to make, like, subject to availability, no rain checks or the like, but you don't trigger the same kind of complex disclosures that you see in a sweepstakes. If you're eliminating chance, we'll talk about that in a minute, it's a contest. So there may be other types of promotions different types of promotions depending on what we're talking about, what elements are present here. Other types of requirements then, once you've gone through that initial lottery analysis and you've satisfied yourself that you don't have something that's that's gambling, that's a criminal operation. You need to then start thinking about the other state law requirements. Pretty much, or just about every state has some sort of requirement that will dictate that you have rules. Some states are very specific about what needs to go in your rules. Additionally, there are some federal laws that will also dictate what goes in the rules. So the FCC, if you're talking about something that has a broadcast component, will say what needs to go in your rules. At the state level, there are rules that will say, here's what needs to go in your advertising disclosures, here's what needs to go in your full rules disclosures, typically things like how to enter, start and end dates, odds disclosures, eligibility requirements. I have a list on the next slide that's going to give you a pretty comprehensive list of what should go in a 50-state compliant set of rules. So you don't need to scribble these down. In addition, I think the full slide deck will be available. But these are the types of requirements that are specifically required under state law. Additionally, there are a couple of states that require registration and bonding. So if you've got a sweepstakes where the total value of all the prizes added together is over $5,000, then New York and Florida will require that you register and bond your promotion, that you obtain a special bond, a sweepstakes bond, for the total value of the prizes. That's cumulatively. So it's not, gee, is there a single prize that's worth more than $5,000? It's all of them added up. The tricky part of this frequently, because you see social media promotions are so frequently put together sort of on the fly, and marketing comes to you a few days before and wants to get things going quickly. It's the modern age. There are advance filing requirements in New York and Florida. New York, it's 30 days, but they're fairly flexible about whether you meet that 30-day deadline. Florida, it's 7 days, and they are very intractable, shall we say, about whether you meet that. So if you fail to do so in Florida, you are then subject to a civil penalty and so it's I believe it's now $1,000 for the first time and then goes up the second time. So that's something to consider. You do have to file your full rules along with the bond and a registration form at the time that you register, and it can be done online. Rhode Island also has a registration, no bonding requirement when there is a retail sort of store component. So if you're running something that's on social media but also is going through stores, you're going to have to worry about registering in Rhode Island if the total value of your prizes is over $500. And they do not have a specific timing requirement for the registration. There is also a registration requirement for skill contests, for specifically amusement contests in Arizona. So not sweepstakes, just contests. And another thing to take into account is there are registration requirements in some other countries that we'll talk about when we sort of talk about international. Some states also require that the rules be posted. Something that's relatively simple, and indeed we recommend in any event when we're talking about social media. It's more difficult when you're talking about something that also has in-store, an in-store component. And then there are a number of states that require some sort of either posting or provision of the winners list on request. So because of privacy, this is a little trickier than it initially seems. The question becomes, do you simply, it's actually the winner's names and location. And so there's sort of, generally we recommend not necessarily posting the names, but providing them on request, which is all that's required. And then, sort of masking some of the information when you have to provide it to the state, but if it's requested by a consumer, doing some sort of masking so that not, people can't go knocking on the winner's doors, particularly for those larger prizes. So here is the sort of list of what types of information we recommend be in the rules. I'm not going to go down the bullet points, obviously, because that would be super boring. But a couple of notes, which is that some of the information in here is specifically required by state law. A few things, and particularly the sort of disclaimers and releases and the like, are not necessarily required by state law, but are what we recommend as being a good idea because of the fact that, things go wrong. And you want to protect yourself as the sponsor in case that happens. The modification clause, say, is something that is really a break in case of emergency type of clause. You actually don't want to be modifying your rules or your promotion, except for, say, that situation like you saw with Google, where, there's potential illegality unless you do, or where you found out there's fraud on the part of, this happened with McDonald's years ago, where the vendor that was distributing the game tickets in the McDonald's games, they're actually making a movie out of this now. I think Mark Wahlberg is, or one of the Wahlbergs. The vendor for the McDonald's game tickets in the Monopoly games was actually counterfeiting them and giving the winning pieces for the big prizes to his friends and family. And so in that case, you could see how McDonald's would want to take some steps to modify how things were working, in addition to going after the people counterfeiting things. But so in that situation where there's fraud or illegality or simply, impossibility, then you could see how a modification would be appropriate. But when you modify, you potentially sort of bring deceptiveness or unfairness complaints down on your head and get yourself into just another pot of trouble. So you want to proceed with care in invoking that modification clause when you might be able to use disclaimers or releases to protect yourself instead. So disclosures, how to disclose rules, how to disclose other key claims about the sweepstakes that you should be making in advertising. In particular, all of your advertising for sweepstakes should include some sort of short form rules, what we call the abbreviated rules or something like that. There's a Florida regulation that they passed a few years ago that specifically lists what that state considers to be sort of the material terms for sweepstakes that they believe needs to be disclosed in all advertising. It's a fairly good summary. It does not 100% line up with, say, what New York considers to be all of the material terms, in that it doesn't include, I think, prize descriptions and value. But it's a pretty good summary, and we have sort of form abbreviated rules that we recommend, and they're always happy to share that with clients. It's important to include these material terms in all advertising. And that, in fact, also includes not only things like eligibility and start and end dates and the odds statement and, what the prizes are and their values, but that free alternative method of entry. as I mentioned before. And so these are those cases where those cases that I mentioned, including the New York Attorney General cases, that's where those cases come in. So the New York AG has brought several significant cases against prominent retailers and brands for failure to disclose the free alternative method of entry in an adequately clear and conspicuous way, which is the FTC's standard for disclosures. And so you can see A&P Supermarkets, H&R Block, we're all thinking about our taxes now, CVS, Tylenol, were all hit sometimes more than once for settlements in the tens of thousands, or in some case hundreds of thousands of dollars, for failure to do this. And that includes sort of the in-store advertising, the on-pack advertising, and additionally making sure in some cases with the retailers that the in-store employees were able to answer, oh yes, you can enter for free. In the case of CVS, people would go in store and ask, hey, this is a great sweepstakes. Can I enter without buying something? And they had no idea. So it's important to be able to make sure that your employees are educated as well, if you're a retailer, as to how to tell people how to enter for free. The FTC has a standard, or has put out education on sort of how to make disclosures in a clear and conspicuous way for online sweepstakes, online advertising in general, social media advertising. What they say is that marketers should keep the 4 Ps in mind. There aren't necessarily fixed rules about font size or color or magic words when it comes to, when a disclosure is clear and conspicuous, but there are sort of basic principles to think about. So the 4 Ps are proximity, placement, presentation, and prominence. But the idea is you want to put your disclosures close to the claim you're making, close to the call to action, so close to the call to enter the sweepstakes. If you've got an entry blank, you want to put the abbreviated rules fairly close to where people are actually going to be filling in their entry. You want to put things where people look. You want to make sure that if you're using a hyperlink in a disclosure, it should be obvious what that hyperlink is. So, you want to make it clear these are the official rules, and that it is a live hyperlink, and it's labeled appropriately to make it clear that, this is what's here. Additionally, one thing that comes up in sweepstakes is the FTC has sort of said 1 click good, 2 clicks bad as a general principle. And so people shouldn't have to go through too many clicks to get to the rules for a sweepstakes, to get to the entry blank that has the abbreviated disclosures, that sort of thing. The other thing is that in general, when it comes to how prominent these disclosures are, you shouldn't be making people scroll way down on a page in order to find important disclosures in general, and we'll talk about this in the context of the endorsements and testimonials rule, but the FTC has said don't put things at the very end of a post or a tweet. So, games of skill and contests. Let's talk about that. In games of skill or contests, consideration is generally allowed. So you can require a purchase or payment in a contest, with the exception that there are a few states like Colorado and Maryland and North Dakota where consideration in the sense of a purchase or payment is not allowed. In Arizona, you have to register any contest where consideration is required. Many of the same advertising disclosures are either required or at least a good idea in contests. And then from there, what types of disclosures are recommended may vary depending on the types of contests we're talking about. So, you see photo contests or essay contests, UGC or user-generated content contests or sales contests, and it may sort of vary in terms of what you want to put in there, and you need to be thoughtful about that. Additionally, when you're talking about these promotions, you want to think about, are you targeting special audiences in trade or employee promotions? Many states aren't regulating that type of promotion, but there may be other issues. For instance, with trade promotions, the commercial bribery laws may be triggered in some cases. So you need to be thoughtful about whether you're getting employer consent to try to avoid those issues. The government may prohibit participation by their employees in a trade promotion. So the rules should take account of these issues. There may be for your own employees, promotions you're offering to your own employees. You need to consider the sort of tax and compensation issues, or to the extent that you're soliciting content from them, there may be work for hire issues that you need to take account of, or other labor law issues to the extent that, you're potentially asking them to work outside of their regular hours for hourly employees. There's also been a few promotions that have triggered discrimination allegations or human rights law allegations in the past few years, where there have been, say, promotions targeting women only or the like. There was a promotion that invited just women to attend a screening of Wonder Woman when it came out. It was, I guess, when was that? About a year and a half ago. And there was a challenge to it based on the Texas civil rights laws. This was the Alamo Draft House Cinemas offered this. And in that case, it was sort of ultimately, the guy who challenged it was sort of ultimately put down by the mayor of Austin. The thing went away. But there actually is a potential challenge that you can register, and there have been challenges over the years to sort of ladies' night type giveaways and promotions based on the civil rights laws. And so, you sort of have to look at the jurisdiction you're in and the environment that you're in before you do a sort of women only, men only, whatever type of sort of whatever promotion of that type you might consider. Just not saying don't do it. I'm saying be aware of what you're getting into. We'll talk about children in a minute, and the issues that come up in that environment. Skill contests and UGC promotions. Skill contests have many of the same issues, or UGC promotions have many of the same issues as traditional sweepstakes, but they present a lot of unique issues as well. We talked about how the absence of chance means that consideration may be required except in a few states. So generally it's a good idea just not to have the purchase or payment, but there may be hidden consideration to the extent that you're asking people to buy a product in order to, use the product and show your results. So you need to be thoughtful about that. Can you do something instead with the branding? Show how much you love the product by doing something with their branding or something like that. In addition, you always want to be thoughtful about, say, to the extent you're having a photo contest or a video contest, you should be thinking about providing content guidelines and moderating whatever content is being submitted because people are endlessly creative, sometimes in an evil way. And so you want to make sure, particularly if you're thinking about posting all of the entries, that you don't get something that is a surprise in a bad way in terms of the content that's being submitted. So you want to make it clear what you're looking for. Open-ended requests often give people too much leeway in terms of their creativity, frankly, where we've seen sort of problematic contests in the past. It's tended to be where you've had very open-ended requests. An example, sort of one of the best-known examples, was a sweepstakes or a contest where there was a request to name a boat by a scientific organization, and they said, please help us name our boat. Submit names, and and then the names were voted on, and the most popular name was Boaty McBoatface. This very serious organization did not want to name their boat Boaty McBoatface. And so ultimately they came up with what was a very clever concept, which was they named the lifeboat Boaty McBoatface. But now, pretty much in like any name this, name that contest, you get entries like X McXface. Which, no longer even as creative as it once was, or even that funny, except for maybe to the submitter. But you need to sort of keep in mind that it's always better to have a very directed request rather than an open-ended request, because you get that sort of Boaty McBoatface or worse, because, people are much more, sort of have much dirtier minds, let's just say that. But in any case, then when you have a contest, generally speaking, it's got to have clear guidelines as well. You should have judging. If it's a skill contest, then you need to have clear criteria to show people, here are the criteria by which you're going to be judged, or the winner is going to be selected, and then the people who are selecting the winner should have some sort of expertise, that for which they can, or have the ability to select. So, judging or the like. That being said, judging and voting can present special concerns in the sense that, voting rather can present concerns to the extent you want to use that as well. So to the extent that you want to use voting, you definitely want to consider sort of, Let me back up a little bit. Let's go judging, then voting. For judging, you want to make sure that the judges have some clear criteria and apply. Preferably, you want to name the judges, but at least you want to make sure that it's clear sort of who they are, what criteria they're using. It's very popular to use voting nowadays as well, because it increases sort of audience participation, if you will, and participation by the public. That is okay. However, it is not clear at this point whether a contest that involves voting is really then it's really a skill contest, because obviously the voting public doesn't have any particular expertise that they are judging with. So typically, if you do want to have voting, then we recommend that they are voting along the criteria of public appeal or something similar like that, and that both for the reason of sort of keeping skill, air quotes, in the process, and also to be able to maintain some modicum of control over the process for you as the sponsor. If possible, you have both a judging and a voting round, in whichever order you like, so that, for instance, you have, a judging round where you pick some pool of, the top 10 entries, and then the public votes on the number one, or vice versa. The public votes on the top entries, and the judges pick the number one. And that then gives you, some control over the process and what ultimately gets selected. You also need to take into account in the rules the possibility of voter fraud, also in the screening, and sort of watch for, say, the same address plus one number, plus two number, plus three numbers, and the like, and screen for that voter fraud. There are also intellectual property considerations, which we'll talk about in a minute, third-party platform rules, and the endorsements and testimonials rules. So let's go on to that. And also with UGC, consider that there's UGC contests, but also there are things like you can have open submission programs that don't necessarily have judging criteria or the like, and you just sort of say, we will pick what we like, but we aren't necessarily awarding a prize. So that's another type of program, or crowdsourcing that has specifically user participation, but again, no prizes. So, there are different types of programs that you can consider in this process. An important note about third-party rights here: users own what they post on social media. The platform rules do not give you the rights to what's being posted. So to the extent that when you write your rules for a contest, you need to be very cognizant that you need to put in the rules, the proper licenses and rights transfers, that you get what you need. Additionally, if you want to use, say, what is being posted on a broader basis, so say you want the winner's post, the photo or video that they posted to be, the center of your new ad campaign, a la Doritos Super Bowl promotion on most years, then you need to draw up proper documentation that the winner will sign in order to transfer those rights. Because when you have people posting, you have issues like copyright. The videos and images are subject to copyright law. You will have people who try to argue fair use, but when you're talking about future commercial use, it's very unlikely that there's going to be that protection. While the Digital Millennium Copyright Act may provide some limited safe harbor for republication on the platform, to the extent you want to take it off the platform or you want to edit it at all, you are in a danger zone. Let's just say that. Additionally, to the extent that there are logos in these videos, people are using third-party products, wearing a Lacoste shirt or the like, there may be issues with trademark in these videos, and probably riskiest with this sort of thing is the right of publicity. One of the key issues to think about in designing these promotions is that to the extent you're asking people to post videos, there may be third parties in these videos. There's, to the extent, anybody posts, they've got the right of publicity, and their own name, voice, likeness, and image are protected. But there may also be their best friend or their sister, and their right of publicity is protected as well. There may also be people in the background whose right of publicity is protected. So you need to think about, do you want to just say the video may only include you? Do you want to say, if the video includes third parties, you represent and warrant that you've gotten permission from them, and you'll provide written proof of permission, upon request? Or do you want to provide some release that they have to upload for all third parties, which of course is onerous? These are things you need to be considering at the outset with this kind of issue when it comes to IP rights. So there are certain things to consider as a matter of best practice with UGC in terms of what goes in your terms and conditions, with publicity rights, with submission guidelines. We've talked about these, and then what goes in what third-party clearance, and then what goes in your winner agreement. You may also want to consider a background check for your winners, particularly if it's a very large prize, if it's a very prominent promotion or the like. Taxes. If the value of the prize awarded in connection with the promotion is $600 or greater, the sponsor will have to report the prize value to the IRS by filing a 1099. You will want to collect their Social Security number with a W-9 form, and then the 1099 needs to be postmarked by January 31st. So just something to take into account in executing here. So the social landscape with this. Each social network has its own advertising rules and usage guidelines. You need to follow them, or you can end up with your promotion being pulled down. I've included the rules in this promotion so you can refer back to them. I'm not going to be able to go through each in detail for timing reasons, but to go through probably the toughest platform briefly, the Facebook here is pretty typical in the sense that it includes specific releases, or you must include specific releases in your rules saying Facebook's not affiliated. You see that for pretty much all of the platforms. Facebook is unique in that you can't like gated promotion, you can't require people to like your page. You also can't require people to share the promotion to their personal pages or timelines. It all has to go on your page or your timeline in terms of the promotion. But you also can't ask them to share on their friend's timeline. What you can do is you can have people comment on a post on your timeline, or use a Facebook feature to vote, or announce the winner on your page, or tag an entrant. So you can do lots. Instagram is similar in a lot of ways, different in some. You do have to ask people for permission to reuse their photos. You do need those same releases and the like, but it's similar in a lot of ways. Like I said, I can't go through in detail for timing reasons. I do want to make one note about Twitter. Twitter is very much a stickler about making sure that you're not spamming up its platform. Twitter discourages the creation of multiple accounts or other spammy activities, and it passed these new automation rules about, I guess, as of November of 2017, that says essentially you can't require people to sort of post the same thing over and over and over again, and it'll search for that and shut you down if you're doing that. Twitter has always said, we want you to be limiting the number of entries or tweets to one per day, and don't encourage retweet to win promotion. So on Twitter, you do want to be saying, limit one entry or one tweet per day. And then, like a lot of platforms, you want to make sure that people are setting their account to public, and it's a good idea to sort of include the at brand name, in the promotion or at sweepstakes. What is important to understand as well is that there's a rule for all of these that you need to be following under the FTC's endorsements and testimonials rule. Under the FTC's endorsements and testimonials rule, if an endorser or an influencer or a sweepstakes entrant, as we'll see, has received some sort of material consideration in return for talking about a product or a brand on social media, it has to be disclosed. So in sweepstakes or contest world, you have to require sweepstakes entrants to include a disclosure indicating that their entry or tweet or post has been incentivized by a sweepstakes entry. So for any sweepstakes where you are asking people to post in order for an entry to win, you have to say, put hashtag company sweepstakes or hashtag sweepstakes name or the like in their entry. You cannot use abbreviations, so that's just something to keep in mind. The other tough thing is also what to do about sweepstakes and contests run by influencers. They're frankly not something that I strongly advocate for because the FTC has indicated that the relationship between the company and influencers is something they do monitor, and you are expected to, in your contract with the influencers, have some sort of policy or indicate an expectation that they will follow the endorsements and testimonials rule, and then monitor and enforce when it comes to that compliance. And so you need to figure out a way to make sure that happens. That's something that you need to work with and think about when it comes to sweepstakes and contests, just like any other part of compliance with the endorsements and testimonials rule. Another area where sweepstakes has popped up is when it comes to incentivized product reviews, which is an area of high sensitivity to the FTC and the states and the self-regulatory group for advertising, the NAD, the National Advertising Division of the Better Business Bureau. So we've seen this in the non-sweepstakes contests in recent cases like the Sunday Riley case at the FTC and the Creation case. But it does include circumstances where reviews are incentivized by sweepstakes. And we saw this at the NAD in a case where an advertiser awarded $25 gift cards to individuals who some individuals, it was a sweepstakes, who posted online reviews of the company's products in a promotion where the rules required entrants to include a disclosure in reviews they were part of in a sweepstakes entry. Unfortunately, it wasn't clear in the email that they sent to consumers that this was a requirement, and it didn't appear in sort of a sample review. And so what happened was that it wasn't always being clearly tagged in these reviews that it was that the reviews were being made because they were a sweepstakes entry. A competitor complained about this. When that happened, the advertiser went back and they fixed it. And they tagged each review as a sweepstakes entry. They made sure that those tags were traveling with the reviews to other sites when they were reposted. They fixed the problem when it came in later emails about the promotion and made sure that the discussion of what the disclosure needed to be was better. And they added the disclosure on a review portion of the promotion website. So NAD said, okay, that remedial action was sufficient, but they also expressed concern about those programs generally because they called into question the reliability of consumer reviews. So, troubling in the sense that the NAD just sort of said, we don't like this type of program generally. So if you are running this type of incentive program for reviews where you're offering the chance to win a gift card if you review, first of all, you should not be saying, only good reviews or the like, or in fact only awarding the cards for good reviews. But you also need to make sure that people actually are, that your instructions are clear and people actually are including those hashtag sweepstakes entry or hashtag sweepstakes disclosures, because otherwise you may be a target. Surprise and delights are something I get asked about often. Surprise and delight promotions are promotions where free gifts are given away to consumers, but neither the gifts nor the promotion are advertised before those prizes are distributed. So the issue is that often there's an overbroad interpretation as to what surprise and delights are. And so you need to make sure that the condition is no pre-promotion if somebody wants to run this. In addition, if you are regularly doing the same promotion over and over again and then sort of, giving prizes on Facebook or whatever to people who are talking, saying good things, which is essentially, that's the surprise and delight. Facebook has said this, and I think they're right. It may be that, it's no longer such a surprise, and you may need to think about a change in tactics and just making it a plain old sweepstakes. The other thing is that you may want to consider, particularly with very large prizes that you're giving on a surprise basis, whether you need to get a release from the people who are receiving the prizes, and also whether you need to make sure that they're disclosing the receipt of that prize in order to comply with the endorsements and testimonials guidelines. So we're going to run over a little bit. You're welcome to stay, but I know we're running long. So I apologize for that, or you can think of it as bonus, however you'd like to think of that. Sweepstakes and contests directed towards kids, in addition to complying with all of the laws we've been talking about, you also have to comply with the federal Children's Online Privacy Protection Act, which applies to websites or portions that are targeting children, or that have actual knowledge that they're collecting information from children. The FTC enforces this. Also, CARU, the Children's Advertising Review Unit, which is a self-regulatory group that's another group under the BBB's sort of umbrella, will enforce as well, and they'll look at, in determining whether it's a site targeted to children, things like the site subject matter, whether there are animated characters or celebrities that appeal to children, things like that. And so operators covered under that rule have to post a privacy policy, provide notice, and obtain verifiable parental consent before collecting children's information, provide the access to and the opportunity to review and delete, and meet certain factors, with regard that are to children, which are listed here. The FTC recently requested comments on the state. They've been going through rulemaking. The important thing here with regard to COPPA is that there is an exception that's described under some FAQs for sweepstakes. It's limited. You have to follow it very carefully, but essentially under certain limited circumstances where you're only collecting the child's contact information and only contact information such as first name and email, and using it only to notify that you have won and then deleting that, or you're only collecting the parent's contact information and notifying the parent that you've done so and giving them the opportunity to opt out, which is known as the multiple contact information. You may be able to run a sweepstakes in this way without going through full parental notification and consent and the like. But it's very complicated. You have to be very, very careful if you're running a sweepstakes targeting children under 13. The other thing is that now there's the California Consumer Privacy Act, which has raised the age to require opt-in consent to sell data from children from children between the ages of 13 and 16. So this has sort of changed the mix a bit, particularly if you're selling data from children. So you need to take a close look if you're working with a child or teen audience. As I mentioned, there's also CARU, the Children's Advertising Review Unit, which talks about what kinds of disclosures you should be making if you are targeting a child audience, because essentially they ask for language children will understand if you are working with that kind of audience, like the odds statement. Instead of saying odds of winning, will change based on the number of entries received. It will be many will enter, few will win, or ask your parents to enter, or the like. They also talk about what types of products are appropriate when you're targeting kids, or that sort of thing. So important to consider as well. In terms of the CCPA in California, this also changes the landscape with promotions generally. Promotions have always been run both in terms of expanding sort of outward visibility, but many promotions are also run to collect personal information like emails and phone numbers and addresses. And so to the extent that you are collecting this information for reasons other than just, I need this information to contact the winner and let them know that they have won, then you need to be considering what the CCPA means. The CCPA has significantly changed the landscape, and I'm probably not telling you things that you don't know, but it's significantly changed the landscape. It's effective as of this past January 1, and it's created a lot of new consumer rights when it comes to access and deletion. It does mean that you should be looking at your agreements, and in particular your agreements with regard to your promotions providers, because the question is whether you want to be making sure that it will not be necessary to treat the agreements with your service providers as a sale requiring disclosure and opt-out on your website. So you want to make sure that you don't want these relationships to be sales unless that's absolutely necessary. There were new regulations issued last Friday, so you need to be taking those into account. And you know, in addition, the non-discrimination provisions, you want to be taking a close look at that, to the extent that they may require a sponsor to collect only what is necessary to execute the promotion. You may have to be prepared to delete the rest upon the request of the consumer. In addition, you want to be looking at how the provisions requiring that if PII is being maintained by a service provider, you'll need the means to access it and collect it within 45 days in response to a consumer request, how that will affect promotions as well. To the extent that you're working with service providers there, that's important to look at. In addition, to the extent that you're running social media promotions that have a refer a friend component, one thing that people don't always realize is there is a case out there that says that Facebook messages are email messages under can spam. And so prize promotions with a refer a friend component need to be vetted generally on social media or off for can spam compliance. To the extent that you are awarding coupons or points or additional sweepstakes entries in return for forwarding a commercial email, including a social media message to friends, then they can trigger the Can Spam Act. Additionally, the platform rules for Facebook and Twitter, as we, discourage any kind of spammy behavior. This is really, everybody's familiar with the rules in Can Spam that say you can't have false header information or misleading subject lines and all that good stuff. But the key element is the fact that referred friends must be vetted against your internal do not email list. So you want to make sure that information that you're collecting and using in the future potentially, you're not then contacting people who have asked not to be emailed in the past. So charitable promotions, as you may know, are heavily regulated in many states. Charitable promotions are generally defined under state law as an arrangement between a charity and a business where the business advertises in a marketing campaign or a sales campaign that the purchase or use of its goods or services will benefit a charity or a charitable purpose. So the key element here is that it's typically tied to the purchase of goods or services, and then it will benefit the charity or the charitable purpose. 26 states have laws here. They can require registration or bonding. They can require a written contract, specific advertising disclosures, accounting. They're a real pain in the neck. And so typically when we're counseling clients in this area, our clients want to know how they can avoid the CCV laws. And so this is where social media promotions can actually be very helpful because what we're seeing an increasing trend towards are what we call free action promotions, where you have, instead of buy this product and we'll donate 5 cents, which is, a very typical free action, or not free action promotion, rather charitable promotion, CCV structure, you have something where there is no purchase required. And so under most states, but not necessarily all, there are a couple where there's not a purchase necessarily required. But under most states, where if you have post to our page or whatever, tweet this and we'll donate $5, that's not necessarily triggering the CCV statute in a lot of states. And so that's where a social media promotion can really be interesting and worth exploring. A little bit on international considerations, and we're coming to the end. It's important to understand that online gaming and sweepstakes laws can vary a lot across the different countries. I'm probably not telling you something that's a shock to you. So you need to check often with local counsel. We're affiliated through the Global Advertising Lawyers Alliance. Allowance is what I give my son, not local counsel. The types of variations that you can see are, for instance, some countries don't allow a cash prize. So Brazil is an example there. Some will require rules translation or specific disclosures in a language. Some require registration even for contests. But for sweepstakes, certainly Mexico, Brazil, Quebec, that's why you see void in Quebec so often, certain provinces in Australia. Sweden prohibited sweepstakes till really recently and is still really problematic. The requirements in different countries can really, really vary, and it's important to understand that and how you address sort of what the risk profile is if you don't limit the geographic reach of your sweepstakes, because you can end up in a lot of trouble in other countries if you don't do that. That being said, it's possible to run a multi-country promotion legally. So you don't have to exclude that possibility out of hand if you want to do it. And we're happy to help you do that. So in terms of some practice tips, we can at least do this by 3:15. To make this all easier, we have lots of forms. We have intake forms. We have form rules that are 50-state compliant. Generally, we recommend sort of an initial review make sure it's not a lottery. And then, you can use forms to start and do some review to make sure you haven't pushed into trouble anyway. But this is something that can be done without, it's a complicated area, but it's not an overwhelming one. It is important to have policies in place in certain areas that sort of brush up against this field, like the social media influencer policies or agreements. If you're going to do social media, your influencer sweepstakes, user-generated content moderation, crisis management policy if something goes south, things like that. If you're doing joint promotions, agreements there, form agreements if you're going to be the prize provider, obtain indemnification wherever possible, representations and warranties clauses, if possible insurance. Make it very clear who's doing what if you're going to do a promotion, who's going to do the registration and bonding, who's the sponsor. It's very important if you're going to be doing joint promotions to make it clear who's doing what. Also, if you're going to do international promotions, strongly recommend hiring local counsel. There is a lot of variation in these rules. And then, of course, keep up to date with the social media platform rules. They change, not necessarily with the kind of fanfare you see if there's a change in the law. They can change them, and they don't necessarily change like the sweepstakes rule. They'll change the developer rules, and that'll affect how you run sweepstakes. But it's a little difficult to find. So we try to announce on our blog, which I recommend signing up for, when there's a big change in the sweepstakes rules for the platforms, but it's important to keep up to date with those. Thanks very much for listening and for being patient that we ran over a little, and we'll be happy to answer questions if you want to email them in.